Yes, this is Jennifer Wilson, and this is my presentation for week 5 in choosing 2 of the cases from Mrs. Johnson's video. The first case I want to look at is the one you see on my screen now in the matter of David T. Woods, which is an Indiana Supreme Court case 638 Northeast 2nd 1253. And in this case, the disciplinary rule that we're dealing with is Rule 1.3, which is diligence. And in the case before us, the Indiana Supreme Court ended up issuing a public reprimand to Mr. David T. Woods. Mr. Woods had been was contacted by a Mr. and Mrs. or John and Tina Robinson to hire them. Actually, it ended up being to hire him for 2 matters. The first was a personal injury case that they wanted to file against the city of Anderson, Indiana. And that was in February of 1984. And Mr. Woods did file his notice of tort claim on time, and he began negotiating with the insurance company for the adverse party, trying to reach a settlement. In June of 1985, the insurance company requested from Mr. Woods that he send them pretty much his damages, medical bills, expenses, things like that. And he only sent them a handwritten list. The insurance company came back and looked and asked him again and asked for the documents, but he never would answer, and they never could get in touch with him after that June 1985 contact. In July of 1986, the insurance adjuster realized that there never had been an actual claim filed. There was never actually a civil suit filed, and so she closed her file. And the Robinsons did not know at that point that their file had been closed with the insurance adjuster. They did not find that out until December of 1987. At the same time, in February of 1984, when the Robinsons initially contacted Mr. Woods, they asked him to file a bankruptcy on their behalf. And he explained, he later told Mrs. Woods, or Mrs. Robinson, Mr. Woods told Mrs. Robinson later that if he filed the bankruptcy, that the bankruptcy court would take into account the pending litigation claim, and they couldn't have a no-asset bankruptcy. She told him to go on and proceed with the bankruptcy. Mr. Robinson never knew that there was the issue that could be related to the pending litigation matter. So Mr. Woods filed the bankruptcy, and on his way to the initial hearing or the first meeting of the bankruptcy, he had car trouble and he couldn't get there. And he called the bankruptcy court, and Mr. and Mrs. Robinson were told that they could reschedule. They elected not to reschedule and represent themselves pro se or themselves. Mr. Woods kept telling Mr. and Ms. Robinson that everything was okay, everything was fine. But then in July of 1987, the Robinsons received a notice of discharge and a show cause notice for dismissal in the bankruptcy. In August of 1987, the bankruptcy court dismissed the Robinsons' bankruptcy, and Mr. Woods told him that he would refile for them and he would pay the cost of refiling. Unfortunately, Mr. Woods did not know that there was a 6-month time period after the bankruptcy was dismissed for which he could not refile. According to Indiana law, he could not file or under the bankruptcy statutes, he could not file for 6 months after the dismissal. But he never told them that. So he didn't know. I mean, they never knew that he didn't refile the bankruptcy. Now, for our case, Mr. Woods went before the Indiana disciplinary board, and they looked at the case at hand, and they realized that Mr. Woods had had a prior suspension, a 60-day suspension. But when they looked at it, they realized that the suspension, that the acts of this case, the Robinson case, had actually happened before the suspension and had nothing to do with the suspension. So for the Robinson case, they issued a public censure. Now, if this case were heard in Tennessee, what I did is I looked at, or went ahead and pulled in a Word doc, the Indiana Rule 1.3, which is here: a lawyer shall act with reasonable diligence and promptness in representing a client. And comparing that to the American Bar Association, the RPC rule, it's exactly the same. And it is the same also in Tennessee. The rule reads the same, that the lawyer shall act with reasonable diligence and promptness. If we look up the definition of reasonable, then it is found in our terminology rule, denotes the conduct of reasonably prudent and competent lawyer. And if you look up prudent and competent in the Oxford Dictionary, it shows care and thought for the future, or having and competent is having the necessary ability and knowledge. And we've talked about in class that it's acceptable and satisfactory, though maybe not outstanding. So when we talk about what is actually competent, the rule for competency says a lawyer shall provide competent representation, which means he requires the legal knowledge, skill, thoroughness, and preparation necessary. Now, obviously, Mr. Woods here didn't realize, for one thing, that the bankruptcy court, he couldn't refile the petition in the 6 months. So he was in violation of Rule 1.3 in the reasonable diligence and promptness, and he waited too long in the insurance case or in the personal injury case to file the matter. Now, in my opinion, Tennessee would have likely issued the same suspension because if we look in looking at the Board of Professional Responsibility case, I looked up some cases that had the same violation, and in this Loudoun County case, Mr. Henry was cited for violating Professional Conduct 1.3, which is diligence, and he had some other things here, but he was issued a public censure. And this Madison County lawyer of Yanwu, I'm not sure how you say his name, but he was also publicly censured for a complaint against him for taking 15 months to do what he needed to do. So he was also found in violation of the diligence rule. Now, for my other case, I looked at at Rule 3.2, which is the expedited litigations rule, and I looked at this Kentucky case, which is the case of the Kentucky Bar against Rodney McDaniel. It was also a Supreme Court case, though, in the state of Kentucky, 170 Southwest 3rd 400. And in this case, the Kentucky Bar filed a 5-count action against Mr. McDaniel. One of the actions was this Rule 3.2 for expedited litigation. And in this case, Mr. McDaniel had been privately admonished 2 times before, though they weren't on this particular Rule 3.2. In this case, Mr. McDaniel represented 8 prison inmates for a civil rights action against the Franklin County Correction Complex. They had been representing themselves, but he entered an order of appearance or a notice of appearance in October of 2001. In March of 2002, he met with the defendant. They entered a joint status report to the court like they were asked to do. And in August of 2002, the defendant served discovery on the plaintiff, on Mr. McDaniel. In December of 2002, the defendant then filed a motion to dismiss or to alter or compel discovery, as Mr. McDaniel had never given him what they asked for, and he failed to answer. In January of 2003, the court dismissed the case with prejudice for Mr. McDaniel's failure to respond. On January 3rd, the dismissal was on January 7th. On January 13th, 2003, Mr. McDaniel answered a show cause and asked for new discovery deadlines. He told the court that mitigating circumstances for this matter were that he had been in a capital case, and he asked that they issue sanctions on him rather than dismissal of the case. 2 days later, the court did set aside the dismissal and ordered Mr. McDaniel to pay the cost and that the defendant had incurred, and he did that. Mr. McDaniel then obtained the depositions of 3 of the plaintiffs, but failed to answer the discovery that the defendant had asked for. On June the 3rd of 2003, the defendant filed another motion to dismiss for not getting discovery, and also said that the plaintiff had not deposed the defendant to establish any of his claims. Mr. McDaniel again did not respond, and the case was dismissed. In February of 2004, Mr. McDaniel got served with a disciplinary complaint, and in March of the same year, he was served with a reminder. Neither time did he answer. In August of 2004, he was served with charges from the Inquiry Commission for the state of Kentucky. And in September of 2004, he got a warning letter, and again, he did not respond. The Board of Governors in this case found Mr. McDaniel guilty of 5 counts of violation of the rules of professional conduct. In looking at the case, the court did not agree with all of what the Kentucky disciplinary board said. They felt like that their actions had been too lenient on Mr. McDaniel, and that he was just ignoring them. And by what they had done before, he'd not changed his actions. So one of the mitigating circumstances of what happened to him is the fact that he just failed to respond in any case beforehand. So the court suspended him, totally suspended him for 30 days and ordered payment of cost. Now, as far as if this case had happened in Tennessee, I want us to look over again. I did a Word document again in this case, and we looked at in the Kentucky bar. The rule says a lawyer shall make reasonable efforts to expedite litigation consistent with the interest of the client. That language is also in the American Bar Association language, in which I have in there twice for some reason. But the Tennessee rule only says a lawyer shall make reasonable efforts to expedite litigation. We looked at reasonable already, where it just shows that they need to be prudent or competent in this case. And in this case, it does not seem that our attorney was acting reasonably. Now, I think had this been a Tennessee case, that Mr. McDaniel would have gotten a stiffer punishment, even if he had only ended up with just the 30 days, because in Tennessee I found two cases, one where a Davidson County lawyer was suspended for a period of 2 years for violation. He had if you remember, Mr. McDaniel had 5 counts. This attorney also had several counts, and he was suspended for 2 years, even though 30 days of that was an active suspension. So he still only had to serve an active suspension of 30 days, and the rest of his suspension was probationary. And then then in this case of a Hamilton County lawyer, Bowman, also had an expediting litigation charge, and this attorney, Mrs. Bowman, she was suspended for 1 year, and in her suspension, well, I know it's in here somewhere. She was suspended for 1 year with only 30 days of it being active. So I think Mr. McDaniel in Tennessee would have received a stiffer punishment. And I'm not so sure that I think he might not have gotten more of an actual suspension as opposed to because he was pretty blatant in ignoring what was going on. So that's my synopsis of these two cases.